Welcome everyone, and thank you for joining us today for our webinar, Legal Hot Topics for 501c3 organizations, liability protection, corporate foundations, joint ventures, and more, presented by Quarles. I am Courtney Lynch, a partner in the Indianapolis office of Quarles. I guide clients across various industries through transactional matters, focusing on affordable housing, religious and charitable activities, small business and healthcare, as well as helping clients with tax exemptions, reorganizations, mergers and acquisitions, and more. Today, I am joined by my colleagues, Sujata Chugh and Martin Childs, whom you will hear from later in the presentation. We will begin the presentation as soon as we cover a few logistical items. All comments in today's webinar are off the record and not for publication. All attendees are in listen-only mode, but we welcome your questions via the Q&A box located below the slides in the webinar dashboard. We will try to hold time at the end to answer any questions that have been received, but if we don't have time to answer all questions during the webinar, we'll follow up with you over email. Quarles is happy to be able to provide CLE credit in most U.S. jurisdictions for Quarles webinars. As of April of 2024, the American Bar Association, the ABA, manages the CLE applications, attendance submission, and certificate of attendance for our external webinars. We have updated procedures for tracking attendance for CLE credit. They include, you must be logged in, participating from your own device, and need to actively watch the entire webinar. Please watch for pop-up polls with audio notification that will appear at several random times during the webinar. You must click on the pop-up polls to verify your attendance. Regulators require attendance to be verified, and this procedure meets that requirement. Please take a moment to review the resources box below the video feed, where you'll find a copy of today's presentation, a survey link to share your feedback, and CLE application information. You can access closed captioning during the live webinar by clicking on the CC icon in the lower right-hand corner of the video player. Today's webinar is being recorded, and all registrants will receive the on-demand link within a few days. Okay, so with that, we will get started. So here is a quick overview of what we hope to accomplish today in our webinar. First off, we're going to talk about legal strategies for liability protection. After that, I will be turning it over to Martin to talk about corporate foundations, best practices and issues. After that, Sujata will talk about considerations for joint venture activities by nonprofits with a spotlight on economic development projects. And as promised, we'll at the end talk about some other common 501c3 issues and hot topics. And if time, we will get to your questions. So first up, we have legal strategies for liability protection. I'm starting with this because nonprofit clients of all types and sizes have really been asking us and a lot of people in our industry about this quite frequently. And so I wanted to start with this and say, well, when does it make sense to think about liability protection? And first, when does it make sense to create new entities or subsidiaries of a nonprofit to better protect it from liability? Well, first off, when we say protect the nonprofit from liability, we might be talking about a few different things, which could be related. On the one hand, we are trying to shield the nonprofit from exposure to damages or from being brought into a lawsuit or from exposure to damages as part of a lawsuit. For example, if there's a slip and fall at a property that real property that the nonprofit owns or occupies or leases, how do we protect that nonprofit's assets and officers and directors and employees from unnecessary liability associated to that? Now, first of all, that liability should be covered by the entity that owns or leases that real estate. And of course, you hope to have insurance that helps cover that as well, both from a defense perspective and to cover any damages. But we also want to think about who owns that real estate or who is leasing it. So this is where we get to the areas to consider when you might think about creating a new entity for liability protection. If you own or you are a tenant of or you manage real estate, especially multiple properties, it may be a good idea or highly advisable to create a new entity or subsidiary to shield off that property or that operation from the nonprofit parent for the slip and fall type real property issues or others that might arise. Another thing is if you're acquiring assets or you're selling assets or you're acquiring a program from another entity, it might be a good idea to think about a new entity or a subsidiary to further protect the parent nonprofit from liability. A couple of other circumstances are if a special license is being obtained or sought, or a new permit is needed, or some sort of governmental regulation or action is needed or sought or being applied for, it might be a good idea as part of that process, depending on what it is, to create a new entity or subsidiary to deal with that and deal that away from the parent nonprofit. And lastly, there might be a good idea, depending on how broad the nonprofit's activities are, to separate certain operations to restrict certain assets and keep things separate for liability protection. Ultimately, this discussion is about protecting the nonprofit's assets and potentially, and very importantly, its officers and directors and employees and agents from liability associated with activities that could be separated into a subsidiary or a related entity, and to create an organizational structure that provides the most protection. So the first example here, and the most common example where new entities and subsidiaries are often created to protect liability, is in a real estate context. I've already talked about if a nonprofit owns or leases or manages real estate, especially more than one property, it may make sense to have subsidiary entities to own or lease that property to help protect the nonprofit parent. The most common example is that a nonprofit could form a limited liability company. The nonprofit is the sole member, and the LLC could own and lease and manage the real estate. The LLC, therefore, with the nonprofit 501c3 as the sole member, is disregarded from tax status perspective, is a disregarded entity, and derives its tax-exempt status from its 501c3 parent, as long as the LLC's sole purposes are also tax-exempt. For example, if the parent nonprofit creates a state limited liability company, and that limited liability company is only owning or leasing or managing the real estate in furtherance of the parent's charitable purposes, that LLC will then continue to derive that parent's 501c3 status. The reason that it makes a lot of sense for an LLC, but it may not always in every circumstance, is a couple of reasons. One, an LLC is very simple to form. Two, it's limited liability to the members of an LLC. And also, as long as it's a sole member, and in certain instances, if there's multiple 501c3 members, it will still be able to derive that 501c3 status. A couple of things to think about, though, in the real estate context is property tax exemption. Many nonprofits and charitable organizations and 501c3s hope to have property tax exemptions in their jurisdictions for any real property that they're owning and leasing, and that's very common. Well, sometimes creating these new structures and trying to come up with subsidiary entities can sometimes make that more complicated, but not always. I have two case studies to talk through with you at a very high level. Here in my home state of Indiana, if a nonprofit 501c3 organization has or is able to obtain a charitable property tax exemption for a property it owns, the standard is that the property must be owned, occupied, and used for charitable purposes. And there's case law supportive of this in Indiana, where if the property is owned by an LLC, occupied by that LLC, but ultimately used for charitable purposes, it is still entitled to that property tax exemption. But it would probably be very scrutinized from a county perspective, because on its face, an LLC sounds like a for-profit enterprise. So I would advise anyone in that circumstance to have that conversation and think through that before just doing it without any advice. On the other hand, there are states like Florida that in certain instances, a property tax exemption is not available, even if the LLC is wholly owned by a nonprofit 501c3 organization that on its own would be entitled to the property tax exemption. I had this come up for a client recently. So just keep these things in mind and weigh the risks and benefits. If a property tax exemption for real property is important to you or is available, before you just start creating subsidiaries and new entities, talk to a lawyer and try to think through that, and so you don't risk losing it. Another situation where you might think about creating new entities and really think through liability protection is in an acquisitions or a mergers and acquisitions context with a nonprofit. One thing you could do is create a new entity or subsidiary when a nonprofit is acquiring new assets, new programs, or acquiring or merging into another entity. Again, this is one thing to think about: liability coming to you from that secondary seller or giver or contributor. You might think about, if you are acquiring assets or programs for another entity, what your transaction documents say, in addition to or separately from if you are creating a new entity or subsidiary. You really want to be careful, and this is very similar to in the regular mergers and acquisitions context. Who is responsible for what as of what date, and what liability do the parties have to each other, and what sort of indemnification do they have to each other as to pre and post transaction liabilities. One good rule of thumb is that the transaction document should clearly require, among most anything else, that the liabilities before the transaction and before the closing date is completely borne by the seller, if possible, or the contributor if there's no cash being transacted. Another thing to think about too in this context is, how are those new assets or those new programs fitting within the existing or the acquiring nonprofit scope and purposes and operations? Does the new programs or these new assets fit within the existing 501c3's purpose? If not, do you need to create a new nonprofit as a subsidiary that would have purposes aligned with what's coming? Do you need to amend the existing nonprofit's documents to be able to cover what you might be including? So really, it's a thinking through what your charitable purposes are, what you have said in your ordinance, and what you've represented to the IRS as 501c3 eligible. And if what you are acquiring doesn't fit within that, thinking through new entities, document amendments, transaction documents to try to make sure it is all covered. Another thing to think about too is, what is the risk of liability from this prior entity when you acquire it or its assets or its programs? Does it make sense for you to shield that risk of what you're acquiring from your existing nonprofit by creating a subsidiary? I have a great example of this as a case study. If a nonprofit 501c3 is a school system or operates schools, and it is acquiring a new school from a different nonprofit, what happens after that transaction if a lawsuit is filed and that names the acquiring nonprofit, so the buyer, so to speak, in this context, which was not in charge of what happened at the time that that lawsuit's facts are at issue. So for instance, if something happened in 2020, a lawsuit was filed in 2022, still ongoing, but names the new nonprofit, and the transaction happened in 2021, well, did the transaction documents talk to that scenario? Was there a subsidiary entity used during that transaction? Is there anything the acquiring nonprofit could have done to shield itself from anything that occurred in 2020 when this transaction hadn't even been thought of? So just really think through before you enter into transactions how you can really try to shield yourself and shield the nonprofit from risk from what had happened before the transaction had even been thought of or discussed. Ultimately, even with transaction documents in place, the acquiring nonprofit could protect itself from having unnecessary liability, extra liability, but having that subsidiary entity as a buffer. So just things to think about if you do enter into acquisitional type scenarios. A couple of other instances where you might think about and raise a liability protection is in the license context. Does it make sense if you are trying to obtain a new license or a permit or some sort of authorization to do something from, let's say, a governmental entity? Does it make sense as part of that process to create a new entity to hold that permit or to hold that license, to manage that license? It could be in a lot of different contexts, but again, something to shield that from liability from the original nonprofit and vice versa. Another situation is just general operations. Depending on how big the nonprofit is and what the scope of the nonprofit is, does it have different buckets of operations within the nonprofit umbrella that it might make sense to distinguish those into different entities and subsidiaries depending on what they do and what the risk is of what they do? Are some environmentally risky? We talked about real estate already, but just something to think about. Again, for-profit businesses do this all the time and have expansive org charts to think through separation of risk and separation of liability. And as nonprofits grow and expand and become large, it's easy to be able to do that as well in this context, but it just requires a little bit more thought into it, especially with protecting the charitability and 501c3 status of the parent and making sure that flows through to any entities and subsidiaries as needed. One thing I want to say here, though, is all of this is in addition to two important things that I don't have on the slide, and one would be insurance. I would say that every nonprofit that can afford it should have insurance to cover its officers and directors with D&O policy, and also different other types of insurance, such as liability insurance, cyber insurance, auto insurance, you name it, to cover the operations that it is doing. So all of this is in addition to that. A second thing to think about that is very state law focused, but is important when I mention the D&O policy, is that nonprofits under state law have the ability to indemnify their officers or directors, and in some circumstances have to indemnify their officers or directors for their actions that are done in good faith for the nonprofit. So again, to further protect those directors and officers, in addition to what state law provides, in addition to what the insurance policy provides, you can always review your bylaws. You can adopt indemnification policies and agreements. So there's so much more than what we've talked about here at a high level that can be done to think through liability protection, especially when it's, in most cases, volunteer directors and officers who may be employees but don't necessarily want to be on the hook personally, especially because no one actually owns the nonprofit. My last slide that I'm going to talk about is, well, why is some of this so important? And I don't want to do a deep dive on this, but I definitely wanted to raise it. And that's the legal concept of piercing the corporate veil. That's a lot of why we are talking about this and why it's important. As it is true for every other type of business entity, it applies in the nonprofit context that formation of new entities and subsidiaries provides liability protection because of this legal theory of piercing the corporate veil. And so what that means is that generally a nonprofit corporation's liability, when sued, is limited to its own resources and not those of its directors and officers personally, or any of its affiliates or subsidiaries. Okay. Well, you definitely want to be sure, though, if you are creating entities to try to protect from piercing this corporate veil, that you don't just create them as carbon copies or alter egos of the parent, because that will not survive an attempt to pierce the corporate veil. What that means is that an affiliate entity or a subsidiary entity, they have to follow their own corporate and operational formalities and adhere to best practices of management. And of course, fiduciary duties of all entities still have to be followed. So acting in the best interests of the nonprofit and any of its subsidiaries, and directors and officers have to discharge their duties in good faith. But the important takeaway here is that if an entity is formed, it can't just be a shell of the parent, and it has to be operated as a separate entity. And before I go, I just want to make sure that give you a concrete example is that if a plaintiff in a lawsuit against a nonprofit wants to pierce the corporate veil, and let's say ABC LLC owns real estate on behalf of its or through its nonprofit parent. If ABC LLC is sued, but also the nonprofit parent is sued, that plaintiff could potentially try to sue the original nonprofit and seek its assets and resources to try to cover that lawsuit, that even though ABC LLC is the owner. Well, it's trying to get to those assets because it's trying to pierce the corporate veil and get to the ultimate parent. And it could do that by showing that the LLC's governing documents weren't followed, or that its employees and officers were completely identical to the parent nonprofit, or that its alter ego was, or that the LLC was just an alter ego of its parent. Now, piercing the corporate veil is not easy to do, and there's a lot of legal cases that have talked about it, not as many in the nonprofit context. But ultimately, the theory is if you want to protect assets from liability and you seek to create subsidiaries and affiliates to do so, that should be done carefully and appropriately. You should engage counsel, have counsel help you along with this. But it's all good to try to think through how best to protect assets, especially as assets are growing. So with that, I'm going to turn this over to my colleague, Martin Childs. Martin?
Thanks, Courtney. As Courtney mentioned earlier in her presentation, I'm going to discuss corporate foundations, and in particular, I'm going to discuss some of the best practices and issues with respect to the formation and governance of corporate foundations. So as a general matter, a corporate foundation is a company-sponsored charitable organization that's created and financially supported by a corporation. Corporate foundations are organized and operated as separate legal entities from the corporation. So usually corporate foundations are structured as either a state charter corporation or limited liability company. And in addition, corporate foundations are organized under Section 501c3 of the Internal Revenue Code and classified as either a private foundation or a public charity. Because corporate foundations are formed under Section 501c3 of the code, they're required to have tax-exempt purposes. Many corporate foundations have a charitable purpose and engage in primarily grant-making activities to carry out those purposes, although some corporate foundations have other tax-exempt purposes as well that we'll discuss in this presentation. So as discussed in the last slide, corporate foundations are either organized as a 501c3 public charity or a 501c3 private foundation. A public charity is a 501c3 organization that generally receives a significant amount of financial support from the general public. And for this reason, public charities have a great deal of interactions with the public when performing their tax-exempt activities. Some examples of public charities that you might know of are hospitals, colleges, museums, and even churches. Private foundations, on the other hand, are 501c3 organizations that are typically controlled by a small group of individuals, like, for example, a family. Private foundations derive much of their support from a small number of sources. And for this reason, many corporate foundations are established as a private foundation because the corporation is the foundation's primary source of funding, as opposed to public charities, where the general public is the foundation's primary source of funding. Now, one thing that distinguishes a private foundation from a public charity is that private foundations have a greater number of restrictions than public charity. So, for example, private foundations are generally required to distribute 5% of their assets each year. Public charities don't have this type of requirement. And I think it's also important to note that even if an entity uses the term foundation in its name, it could still be categorized as a private foundation or public charity. There are multiple benefits with forming a corporate foundation. One such benefit is that corporate foundations allow a corporation to define the scope, structure, and focus of the corporation's corporate giving. So, for example, a corporation through its corporate foundation can focus its charitable activities and giving on a city or state in which the corporation's headquarters is located. In addition, forming a corporate foundation also enhances employee satisfaction and pride. Many employees find happiness and satisfaction in knowing that the company for whom they work has some sort of established charitable organization that performs philanthropic work in the community. Also, there are reputational benefits for a corporation as a result of its association with a corporate foundation. So, for example, when a charitable organization is associated with the corporation and that charitable organization does great work within the community, those community members will associate this work and the charitable foundation with the corporation. And finally, for many, this is the most important benefit of forming a corporate foundation, is the fact that the donations that are made to the corporate foundation are tax deductible. Now, there are also multiple risks and hazards that come with forming a corporate foundation. For example, a corporation can experience reputational harm if the corporate foundation experiences administrative or other governance type of problems. We most often see this occur when a corporate foundation has its tax exemption revoked by the IRS because it failed to file its annual returns for 3 consecutive years. We also see reputational harm occur when a corporate foundation experiences theft or fraud by one of the foundation's officers or directors, and the community or general public associates that theft or crime with the corporation. There's also a good deal of cost and time that's associated with administering and governing the corporate foundation. So as a separate legal entity, corporate foundations are required to follow very strict rules under Section 501c3 of the Internal Revenue Code. And failure to follow these rules could result in costly penalties or even the revocation of the foundation's tax-exempt status. So corporate foundations should therefore have some individuals who have knowledge of these rules to ensure that the foundation remains in compliance with these rules. And then lastly, corporate foundations also have additional compliance obligations. So for example, there are some states that require corporate foundations and charitable organizations in general to register with the state before soliciting donations or engaging in any type of fundraising efforts. And by failing to do so, it could result in costly penalties and fines. So now I want to discuss for a few minutes some of the decisions that a corporation will need to make when forming a corporate foundation, and then also discuss the results of such decisions. The first decision that a corporation will need to make is what type of control, or what is the level of control that the corporation will have over the corporate foundation. Generally, if a corporation wants to exercise a high level of control over the corporate foundation, the corporation might be the sole member of that corporate foundation. They might also have the power to appoint the governing persons. So that includes appointing the directors and officers of the corporate foundation. In addition, they might also want to set the mission, the purposes and activities of the corporate foundation. If the corporation wants to exercise a low level of control over the corporate foundation, the corporation might not be involved in the board at all, or might not have authority over the missions of the corporate foundation. And if the corporation wants to exercise, a medium level of control or some type of control that's between a high level and low level of control over the corporate foundation, the corporation might have the ability to appoint a board representative, so someone who would represent the corporation on the corporate foundation's board. And the corporation might also set the foundation's mission. And we generally see companies, especially larger companies, have a medium to high level of control over the foundation, just because that corporate foundation is a representative of the corporation. And the corporation wants to make sure that they have some level of oversight over the corporate foundation's activities. The next decision is to determine the corporate foundation's purposes and mission. So as discussed earlier, most corporate foundations are grant-making only foundations. So these are corporate foundations that only make charitable grants to the general public or to individuals in furtherance of the charitable goals of the corporate foundation. However, corporate foundations can engage in other tax-exempt purposes and have other missions in addition to grant-making missions. So that can include educational missions, scientific missions, literary missions, and they can also engage in other types of activities such as direct disaster relief and scholarship programs. The next step is to determine how the corporate foundation will be funded. Generally, if the corporation is going to be the sole source of funding, then the best avenue for creating the corporate foundation is to create a private foundation. And as we discussed in one of our earlier slides, private foundations receive a great majority of their donations from a single source or a limited number of sources. If the corporate foundation is going to engage in public fundraising, so that means generating a lot of the funds that it receives from the general public, then the best avenue for creating a corporate foundation is to form a public charity, because again, public charities receive a vast majority of their charitable donations from the general public. And then if the corporate foundation is going to receive charitable funds from a combination of the corporation and the general public, then a determination needs to be made on whether to form a private foundation and a public charity. And we'd be happy to discuss that with you should you choose to form a corporate foundation and have questions on whether or not to form a public charity or private foundation. And one of the last decisions that you'll need to make is to determine how involved the corporation will be in the corporate foundation's activity. So if the corporation is going to have a low level of involvement in the corporate foundation, then that means that usually the corporation won't provide any type of staff or administrative support to the corporate foundation, and the corporate foundation is going to bear all of those expenses. Contrastingly, if the corporation is going to have a higher level of involvement in the corporate foundation, then that means that the corporation might provide free employee service to the corporate foundation. They might also provide office space to the corporate foundation. We've also seen some corporations provide accounting services and legal services free of charge to the corporate foundation. And then there's always somewhere in between, a medium level of involvement where the corporation provides some services free of charge to the corporate foundation while kind of taking a hands-off approach with some of the other services that the corporate foundation might need. So corporate foundations, as we mentioned a little bit earlier, can engage in activities other than grant-making activities like disaster relief programs and scholarship programs. And for our purposes on today, we have a limited amount of time here, so we won't describe each of these programs in detail. However, for your purposes, I think it's important for you to know that each of these unique opportunities have various restrictions and rules that affect the foundation based on whether it's classified as a public charity or a private foundation. And again, we'd be happy to discuss those restrictions and rules with you should you have any questions. So we've spoken at length today about corporate foundations. However, the formation and operation of a corporate foundation isn't the only way that your corporation can engage in philanthropic activities. So one alternative to forming a corporate foundation is establishing a corporate giving program. A corporate giving program is an internal program that makes direct gifts to charities. And there are many different types of corporate giving programs. A few examples of them include a matching gifts program. So this is a program where a corporation will match the charitable donations that their employees might make to a charity. They can match the gifts, 1-to-1, 2-to-1, or any type of way that the corporation desires. In addition, a corporation might have a volunteer grants program where the corporation has established relationships with charitable organizations in the community and encourages their employees to go out and volunteer with those organizations. Now, the benefits to having a corporate giving program are very similar to the benefits of having a corporate foundation. Any donations made to 501c3 charitable organizations, particularly the public charities, are tax-deductible donations. In addition, employees will have increased pride and engagement knowing that their corporation is facilitating, being involved in the community, volunteering, donating to charitable organizations. And then there's also reputational benefits that the corporation might experience as well, should the corporation run, a very good corporate giving program. But another great benefit in running a corporate giving program results in the lowering of operational costs. So as we discussed, there's a great deal of cost that occurs when running your own corporate foundation. However, if you're running a corporate giving program, the corporation doesn't have to worry about these costs because they haven't established a separate legal entity. They're only, making donations to charitable organizations or encouraging their employees to volunteer with those organizations. And now I'm going to turn it over to my colleague Sujata, who will discuss joint venture activities by nonprofits.
Great, thanks, Martin. Thanks everyone for joining us. My name is Sujata Chugh, and I am Senior Counsel here in the Indianapolis office. And I work with Courtney and Martin frequently in our tax-exempt organizations practice within our business law group. So I'll be talking a little bit at a high level about joint venture activities for nonprofits. As projects and economic considerations grow, I will say, increasingly complex in these times, joint ventures are more frequently being considered. Joint ventures can take a variety of forms. We could have a for-profit company with a nonprofit and nonprofit, or a nonprofit forming a for-profit subsidiary. As you might be able to guess, the nonprofit to nonprofit joint venture will be simpler, both from a legal and tax perspective. The other two, anytime you are combining forces of a for-profit and a nonprofit, it does get more complex. So there are a number of do's, I'll call them, when a nonprofit is considering a joint venture. Some of these are really foundational to your consideration of whether a joint venture is the right vehicle, or it may be a good vehicle that could work, but is it worth the restrictions and the time and energy that it would require to structure it and to maintain it and operate it on an ongoing basis in accordance with certain restrictions. So in a joint venture context, a nonprofit should always be mindful of the amount of time and resources that are spent on activities unrelated to the nonprofit's charitable mission and purposes. For a nonprofit in just about any aspect of operations, staying focused on your exempt purposes and making sure that your operations and activities are always furthering your exempt purposes is of primary importance. And the reason why that's important is the next bullet point, because a significant amount of unrelated business activity is likely to generate what we call UBIT, or unrelated business tax income. So the joint venture, depending on what it is doing and how it is related to the founding nonprofit's exempt purposes may generate UBIT or more UBIT than the nonprofit ultimately decides is worthwhile. As a small side note, even without a joint venture, there are certainly lots of times when a nonprofit organization will decide to engage in unrelated business activities, knowing full well that it will generate taxable income. And they've made a business decision that that is worth it for them, that paying the tax on the income that that generates is still a worthwhile endeavor, perhaps for reputational reasons, perhaps for strictly economic reasons. The tax is worth it. So it doesn't mean that it's a fatal flaw in a joint venture activity, but it is something to carefully look at. Also in a joint venture activity, one of the foundational principles is that whoever the nonprofit is combining forces with, is venturing with, and especially if it's a for-profit entity, there has to be special importance given to actions taken to protect the nonprofit's tax-exempt status and to ensure that the joint venture's activities remain charitable in nature. If they don't, that could jeopardize the nonprofit partner's tax-exempt status. So certain ways of doing that are through governance structures and the financial structure of the joint venture. So for example, maintaining sufficient control and power over the joint venture's activities. It will matter how the governance structure is set up in that joint venture. It will matter how the financial valuations, both the contributions and how the revenue is shared, is set up in terms of how that could impact the nonprofit's tax-exempt status. And all of these issues are important because they are being undertaken so that the nonprofit is sure to comply with private benefit and private inurement doctrines under the IRS regulations, which I know many of you are familiar with, but in a basic sense, go to the very heart of the nonprofit's formation and the commitment that a nonprofit makes in exchange for receiving C3 status and the deductibility of donations and the exemption from many of the taxes, that there will be no private benefit or benefit to a private individual. Now, in a for-profit company, of course, that is the point, right? Benefit to individuals in a closely held corporation and benefit to shareholders in a publicly held corporation, in a large publicly held corporation. So, but in a nonprofit, that has to be different. All of the assets are charitable in nature, no one owns it, and as a result of its activities, there can't be a benefit accruing to private individuals. So all things that have to be carefully looked at in a joint venture context. We're going to spotlight economic developments in this conversation around joint ventures. And that's because, first of all, quite simply, we're seeing these issues come up with clients more and more. I think that as both governmental entities and, for example, corporations and the communities that they live in look to principles of placemaking and quality of life in communities, that economic development has been and continues to be an increasing focus. These types of projects are usually pretty complex. They involve a number of different variables, and as a result, involve a number of different players, and hence the propensity towards potential joint ventures. So you could have for-profit companies involved, nonprofits involved, governmental entities involved, and usually not one of them can really accomplish these goals on their own, and they're looking for different ways of collaborating. So when we think about economic development, we think, most of us are familiar with all of these activities, that the provision of assistance to individuals or for-profit businesses in a community, right, in a particular area, and usually with the goals of encouraging new businesses to open, retaining existing businesses, and developing or retaining local jobs. Usually you want to further other bigger, broader community needs and grow the economy generally in that area. Nonprofit institutions, especially educational institutions and cultural institutions, may be attracted to participate in economic development projects that could involve a joint venture. And usually this comes from the DNA of that type of a nonprofit organization, right? What it feels it is its mission, its calling, not only perhaps narrowly to help its students get an education at that economic development institution, but usually, a college or a university might take great pride in the fact that it is an active and economically important member of that local community and want to give back. We have also seen several official projects at a state level whereby state governments are increasingly turning to educational institutions to, in fact, step up and play a role in their community to improve the local community, the local economy in that area. So economic development, interestingly, is not a defined term in the Internal Revenue Code or the Treasury regulations, and there is not actually binding IRS guidance around this, and I'll get into that in the next slide. Economic development and entrepreneurship are good and desirable things. I think we would all agree, but an important takeaway is the understanding that they are not necessarily charitable. They are not defined so by the IRS. One cannot make the assumption that simply because it is economic development, it must be charitable. There are certain criteria and I will say hoops to jump through to be able to try to get a project classified as charitable. And in terms of a nonprofit's involvement in that joint venture to make sure that the nonprofit's charitable purpose is protected. So it's critical that any 501c3 getting involved in a joint venture around economic development goes through the careful analysis, and again, a little bit more information on that in the next couple of slides, and that there is a 501c3 justification before engaging in these activities. It, again, comes very naturally within the DNA of most nonprofits to want to help and improve, especially the area in which they reside and the nonprofit makes its home. But that doesn't mean that the project that they are thinking of engaging in is necessarily within the exempt purposes of the organization. So one has to be careful to separate, justifiable exempt purposes and the general desire to assist and do good in the community. So here are some examples of economic development that I think we would all be familiar with. Maybe we are seeing in our local communities at this very time that thinking about being involved with. I'll pause for a second on this slide to allow you a chance to read it. So a little bit more on the IRS position on economic development. Again, unfortunately, it's not a defined and recognized official term, although we know it in common parlance, and I think we would all say that we have kind of a shared mainstream layperson understanding of it. IRS guidance involving nonprofits and economic development or charitable economic development over the years is actually non-binding. It is spread out through a collection of different guidance documents and rulings. And it honestly hasn't been kind of officially updated or overhauled in a comprehensive way in the nearly 30 years since it has been released again in the form of different pieces of guidance. So again, economic development is not classified or cannot automatically be assumed to be a charitable activity. Rather, based on the IRS non-binding guidance, we see that there are a multitude of intersecting and overlapping factors that, when taken together, can make the case that this is a charitable endeavor. So to go through these briefly, to qualify as charitable economic development, the activity must be in an economically depressed or blighted area and benefit a disadvantaged group. And we've included some examples of disadvantaged groups around whom economic development has been recognized to be charitable. And then a third factor, and we intentionally have the and or and a question mark because again, it's not, there is no straight shot, bright line guidance on the addition of these factors in number 3 and how they all intersect. It's a very case by case analysis. The economic development should also aid businesses that have experienced difficulty in obtaining conventional financing. So it may be a private small business, but it cannot obtain a conventional bank loan because of the blighted nature of the area. Perhaps it could be because of certain racial considerations or factors or the experience of discrimination. An additional element in that would be that the economic development or the small business would locate and remain in that area, right? Help keep sustaining that area and provide jobs, but only if the economic development assistance were available. Otherwise, they would likely leave the area, further deteriorating conditions. So, important questions that a nonprofit needs to ask before considering engaging in economic development activities. The first and foremost and most essential is, how does the specific proposed project further the nonprofit's charitable purposes under Section 501c3? This is not to say how it furthers general charitable purposes, something that we might think of in a lay understanding as charitable, but that nonprofit's specific charitable purposes under which it applied to the IRS to be classified as a 501c3. So for example, if one is a college or a university, obviously a core charitable purpose that under which one would have gained tax exemption is the educational mission. Is this joint venture that you're considering do things to further the educational mission, or does it just kind of tangentially help the community that you happen to be in? What will your nonprofit's role be in terms of a partnership in the joint venture, and what is the financial structure of the project? And that's very important for considering private benefit and private enormement doctrines. We went through this with a client where that client was going to need to hire to engage a private sector company to do some of the maintenance and operations on a facility that it was, I will say, investing in some way as part of economic development. But the way that the nonprofit was initially considering putting together the contract and the structure would have likely resulted in private benefit to the for-profit management company. And we had to advise them that it must be restructured so that that doesn't happen. And again, another basic question, is it in fact a joint venture or some other kind of partnership? And who is the specific grantee or counterparty, and do special rules apply? So some practice pointers, of course, document, and that includes not just internal operational documentation, but also board action on this. Board consideration, deliberation, board votes on it to make sure that the support has been there at the highest levels for the nonprofit's engagement in this. If there might be board members that are somehow engaged in the community, and there might be a conflict of interest, to make sure that there are appropriate recusals, et cetera. Looking at what your peer funders are doing, investors and partners are doing, and demonstrating that any small amount of private benefit, which can be permissible in some circumstances, to demonstrate that the charitable results will significantly outweigh any private benefit. For example, if part of the economic development joint venture is to help sustain small, struggling businesses, mom and pop shops and operations, there is a private benefit there. There are private business owners who would benefit from, let's say, small business incubator loans, but the charitable results to the community could be shown to significantly outweigh that. Demonstrating both on paper and in your operations that the activity furthers your exempt organizational purposes, and carefully analyze structures and contracts, to my earlier example, to guard against private benefit. So with that, we'll wrap up the section on joint ventures. Obviously, it is probably clear to you that it's a very case-by-case and sort of customized analysis depending on the parties, the goals, and the financial incentivizations involved. We'll now turn to a very, very cursory overview of other timely topics that we see our nonprofit clients facing and around which we have the capacity to assist and help be thought partners and help troubleshoot. So the first of these, and again, this is a smorgasbord of the big issues that we're seeing continually with our clients, has to do with Section 501R compliance for public charity hospitals. Section 501R, is any hospital or healthcare clients who are on the call are probably very familiar with. That section sets rules for 501c3 hospitals to meet certain requirements under the Affordable Care Act having to do with financial assistance that they provide, emergency medical care, and addressing community health needs. It's a very exacting area of the law. The regulations are extremely dense and nuanced, and we are seeing that this is an increasing area of attention and scrutiny and enforcement for the IRS. So we do expect to see greater activity from the IRS in this area. We work with many hospitals to help them get all of their necessary protocols in place and policies aligned with the requirements of Section 501R. Another area that affects actually all nonprofit organizations that have paid leadership is executive compensation. And here it's not so much a new or kind of troubleshooting issue, but just pointing out that the IRS regulations in this case do have pretty helpful safe harbor guidelines, which if the board follows, do create what's called a rebuttable presumption that how that nonprofit board has set executive compensation is reasonable. And if the IRS were to question that, it would be on the IRS to demonstrate that they're not reasonable. So it's well worth it for the board to follow these safe harbor guidelines, and we've assisted many organizations in making sure that they do so. With an election year coming up, we wanted to just very lightly touch on political activity and lobbying activity. Basically, the general prohibition on political activity for 501c3 organizations. That is pretty much blanket and absolute and has to do with partisan political activity and participating in, directly or indirectly, or intervening in any political campaign for elective office. Certainly a lot going on with college campuses right now that institutional leaders are examining, and we're happy to talk through more of that. 501c3 organizations are, however, allowed certain limited amounts of lobbying, and the IRS has a couple of different tests around how they judge that. And we're, again, happy to talk through more of that. As Martin is about to talk about in a second, a lot of our 501c3 clients will have affiliated or sister 501c4 organizations who are allowed to engage in political activity and substantially more lobbying. So a lot of times it makes sense to have both of those entities to achieve the overall mission. And with that, I'll turn it over to Martin to cover the last couple of points.
Thanks, Sujata. Another common issue that we see some of our 501c3 clients have involve relationships with affiliated organizations. And this is generally a dual entity structure type of relationship that allows entities such as a 501c4 entity perform activities that a 501c3 organization is prohibited from performing. And in these types of relationships, we usually see issues regarding the structure of the relationships, contractual issues that might come with the sharing of staff, property and other resources, and other types of issues that affect the relationship between the 501c3 organization and their affiliated organization. And then lastly, we also see issues that face donor advised funds. And very recently, there were new proposed regulations affecting donor advised funds that you all should be aware of, to the extent that you either work with a donor advised fund or have a donor advised fund. And again, we'd be happy to discuss those regulations with you if you have any questions. Now I'll turn it back over to Courtney.
Thank you, Martin, and thank you, Sujata. And I note that we have 1 minute left, so I don't think we're going to have time for questions, but any questions that we did receive, we will follow up with you all separately. So the last slide here is just to give you a laundry list, which is very long and probably in small print on your screen, but all of the things that Martin, Sujata, and I, and others on our Coral's tax exempt organizations team can help you with in the context of 501c3s and nonprofits and everything like that. But I will put our contact information on the screen. Please feel free to reach out to us. We're super happy to answer your questions, and we certainly appreciate your attention and your time today. So thank you very much for joining. I see that the hour is up, and I will log off. Thank